Welcome all to the channel Scientellectual. In the current video, we are covering two more sections under Chapter 18, Suits Concerning Infringement of Patent of Indian Patents Act 1970. Sections are 113 and 114. 113 deals with Certificate of Validity of Specification and costs of subsequent suits for infringement, and Section 114 deals with relief for infringement of partially valid specification. Section 113 Certificate of Validity of Specification and costs of subsequent suits for infringement thereof. Subsection 1 In any proceedings before Appellate Board or High Court, and the proceedings is regarding the revocation of a patent under Section 64 or Section 104, the validity of any claim of the specification is contested. That is, for any claim of the specification, there is a question on validity of that claim. And if the Appellate Board or High Court finds that the claim is valid, then the Appellate Board or High Court may certify that the validity of that claim was contested in those proceedings and was upheld. That is, when the validity of any claim is questionable or being contested, that is some kind of opposition, then Appellate Board and High Court, if they find that it is valid, the claim is valid, then they will certify it. Now, what is the purpose of Certificate of Validity? Certificate of Validity is basically a tool for self-defense for the patentee, that these claims are valid and we have or I have certificate from Appellate Board or High Court. He can use it to restrain further infringement of the patent he owns and for which he had filed infringement suit earlier or succeeded as plaintiff. Or in spite of showing this certificate of validity, if any infringement occurs, patentee even may claim for cost for damage occurring in the validity challenge. So these are the plus points of getting a certificate on validity of any claim. Section 113, subsection 2. Now, where such certificate has been granted, that is, certificate of validity of any claim has been granted to patentee, and if in any subsequent suit for infringement or subsequent proceedings for revocation of any patent, the patentee or other person who is having the validity certificate of any claim obtains the final order or judgment in his favor because his claim is having validity certificate from Appellate Board or High Court. So the final order will be in favor of him. And in that case, he shall be entitled to order for the payment of his full cost, charge, expense, etc. regarding the proceedings or suit properly incurred so far. So he can demand charge regarding the proceedings as they concern the claim in respect of which the certificate was granted. It is obviously related to the claims which has or which have the validity certificate. So he can demand the expense or charge or full cost regarding the proceedings of that suit unless and until court directs anything else. Now, provided the cost shall not be ordered when the party disputing the validity of the claim, that is, who is alleging that these claims are invalid, that person, if he proves that he was not aware of the grant of the certificate when he raised the dispute, and then when he came to know, he withdrew his objection. So, it is the responsibility of the patentee to put the notice of certificate of validity on time before the infringement takes place so that other person get to know that this claim has already got the validity certificate. So these are not questionable. Section 113, subsection 3. Nothing shall be construed as authorizing the court or the appellate board hearing appeals from decrees or order in infringement suit or petition for revocation to pass the order for cost on the scale referred to therein. That is, as per this subsection, the IPB or the court is obliged to pass an order to the cost, but not at the scale as demanded by the patentee. The court or IPB will decide the amount. Section 114. Relief for infringement of partially valid specification. Subsection 1. In any infringement proceeding of a patent, if it is found that any claim of the specification, being a claim in respect of which infringement is alleged, that is, there are few claims, and regarding those claims, against few claims there are infringement. And if it is found that those claims are valid, but that any other claim is invalid, that is, there are say 10 claims and 5 of them are valid and maybe rest 5 are invalid, then the court may grant relief in respect of the valid claims which is infringed. So if those 10 claims have been infringed, then court will grant relief only for those 5 valid claims, provided the court shall not grant relief except by way of injunction. That is, court will not grant any relief except injunction. Subsection 2. Where the plaintiff proves that the invalid claims was framed in good faith and with reasonable skill and knowledge, that is patentee, whose claim has been infringed. Now, if he proves that although the rest 5 claims, for example, are invalid, but those were written or framed with good faith and with reasonable skill and knowledge, then court shall grant relief with respect to the valid claim which is infringed, subject to the discretion of the court as to cost and as to the date from which damage or account of profit should be reckoned. And in exercising such discretion, the court may take into consideration the conduct of the parties in inserting such invalid claims in the specification or permitting them to remain there. So if the rest of the invalid claims, if they were framed or written with good faith and with reasonable skill and knowledge, then court will take into that in consideration. Thank you all the viewers for watching the video. If you like it, please give a like and please share and subscribe the channel Scientellectual. In our upcoming videos, we will be covering rest of the sections under Indian Patents Act 1970. In this way, we are covering all the sections, rules and forms and fees, etc. regarding Indian Patents Act 1970, which will be very helpful during the preparation of Indian Patent Agent exam. Thank you all.